Everybody get a sample ballot and a booklet. In 2012, when all those amendments were on the ballot, if somebody brought in a help sheet or a sample ballot, they averaged about 12 minutes. If they didn't bring one in, they averaged 45 minutes. And we had some that were 2 hours. So you can carry that piece of paper in the polling place. We got word today, if you live in District 4, there's not going to be a county commissioner race in that district. Mike Dowdy pulled out of that race. I've been getting a bunch of phone calls asking about West Florida and voting. And I'm going to say this, and those supervisor of elections in those 7 counties, Gaston, Gulf, all of them over there, Bay, I have all the faith in the world with them. I was over there Thursday, Friday with Gulf County. I went to Bay County Monday morning, was back in Gulf that afternoon, or around lunch, and met with the Secretary of State over there to figure out a plan in place and what to do. I don't know, the pictures on TV does it no justice. It's like a bomb went off. The supervisor of elections in Bay County has 44 locations, precincts, and he's probably going to have 5 on election day. And what they're going to do is they're doing vote centers, and I wish Florida would go to this anyway. When they start this, the 27th, in those 5 locations, goes all the way up to election day, and it's not going to stop. Bay County, most all of those counties are going to that. People can pick up absentee ballots for other people now. Usually you have to wait till 5 days prior, and it's only in those affected counties. So in Madison County, we can't do that. But again, they did LNA testing in Gulf yesterday. We also did it yesterday. But the majority of them did it yesterday, and Bay County did it today. When the storm came through in Bay County, the supervisor of elections and part of his staff was in that building, and the roof literally lifted off of the building. When I was there Monday, they had already gotten a roof halfway put back on that building, and they haven't left since in daylight hours. He's been pulling 16-hour days, and the staff's been pulling 12-hour days. So there's a group of us going over there this weekend that's going to help clean up their yards, because they won't get to it until the election's over with. Anybody got any questions on any of that stuff? All right, as y'all know, early voting starts in Madison County on October 27th, and it ends November the 3rd. I don't care where you live in the county, you can go to Greenville and vote. You can go to Pinetta Fire Department, you can go in here, you can go to Lee, any of those locations and vote. We push early voting real hard because of if somebody gets sick or if something happens, then it's already out of the way. And if you look at numbers, it's typically easier for people to early vote than it is to show up on election day. So I say all that to say I want to thank Tommy Reeves. 2012 he did this, and he did an awesome job on it. And so I'll just sit back and take notes. Hope you don't get lost. Thank you.
Thank you. Okay, well, hello everybody. My name's Tom Reeves. I'm the county attorney, and so Tommy and I have gotten together every 2 years, and I try to explain, what's going on with these amendments. Now, everyone, if you can you hold up that booklet? Sure. Do y'all have, if you can get one of those or get where you can see one of those, what we're going to do is I'm going to kind of walk you through, and I think Robbie, he may be going to get some. I think those may be in Spanish. Take a look. He had one box in Spanish. Yeah. I take a look and see. I don't know. Yeah. I think Tommy's going to get some more. But anyway, so we're going to walk through that. And what we're going to do is talk about the constitutional amendments. Now, in Florida, we have a constitution, and then we have statutes, and then under that you have administrative rules and county ordinances and city ordinances, all that. The Constitution is the supreme law in the state of Florida. It's no one has any greater authority in the state system than is as given by the Constitution. So if the Constitution says it, they can't change it in the legislature, they can't change it at the county level or anything like that. Of course, it's, you know, our state constitution is subordinate to federal law. So if you've got a federal statute or a federal constitutional provision that goes the other way, we of course are bound by that. So what we have really every time there's a general election, constitutional amendments can be proposed. And those constitutional amendments go on the ballot. They have to be approved by 60% of the voters in the state of Florida. So if you've got, you know, what do we have in Florida? 20 million people now. It doesn't matter how many people we have in Florida. It doesn't matter how many people are registered to vote. It's 60% of the folks that show up and vote at that election. If those folks vote for the amendment, then it becomes part of the Florida Constitution. Now, the amendments can get on the ballot in a number of ways. One is the legislature can propose them. There's initiative provisions, all of that. Every 20 years in Florida, what can happen is we have a constitutional convention. That's what we've done here. The constitutional convention, for the constitutional convention, the president of the Senate appoints several members, the Speaker of the House appoints several members, the governor appoints several members, Chief Justice appoints several members, and then they propose a slate of amendments. That's what we've got here. These are the amendments that came from the Constitutional Revision Commission. Biggest difference, from a voter's perspective, is that regular constitutional amendments generally have to be limited to a single subject. Constitutional amendments that come from the Constitutional Revision Commission, there is no similar prohibition. So as you'll see when we go through, you've got some amendments here that have some kind of pretty wild differences, and it's things that aren't necessarily related to one another. But that's legal as long as the courts feel the voters can understand what's going on. So anyway, let me just dive in. And first one is going to be amendment number 1. Now, for this, you got to realize how we actually do things in Florida tax-wise. Local governments and counties, cities, school boards, and special districts are funded by ad valorem tax generally. Ad valorem tax is the tax on real property. It's also the tax on personal property if you have farms and businesses. You can have to pay that. But it's based upon a percent of the value. And now a percent, and percent is actually not accurate, percent is 1/100th. 1% is 1/100th. Ad valorem tax is based on millage. Millage is 1/1000th. So if a county levies 1 mill, what happens is that the value of your property, if your property is valued at $1,000, that 1 mill brings in $1, right? That's how that is determined. Now, under Florida law, we have what are called homestead exemptions. Most states have that. That says the first however many dollars worth of value on your home is not taxed, right? For years and years, it was $25,000. So if you had a $40,000 house, if you had a house that was valued at $40,000, you were only taxed at $15,000. 40 minus 25 equals 15. Right? Then several years ago, they changed that to where they added another exemption. Right? So the way it works in Florida is the first now 25 is absolutely exempt. You skip 25, right? The next 25 there is an exemption. This is all presently under Florida law. This Article 1 is talking about adding another exemption between $100,000 and $125,000. Okay? So therefore, if you have a house and the value that the property appraiser puts on that house is over $100,000, you would get some relief from this. Your taxes would be a little bit lower than they otherwise would. If you have a house that's worth $99,000 under the property appraiser system, it's not going to affect you. Okay, does that make sense? So when you're trying to decide, and always remember with these kind of amendments, if you take away the ability to tax in one area, you want to be careful because you may be encouraging government at that point to tax in another area. So you're talking about, you know, there's hardly any exemptions or hardly any relief from taxes that people don't like. But the question is government going to decrease providing services, or are they going to find somewhere else to tax? And that's what you kind of have to weigh out when you're looking at these. But the effect of it, like I said, the effect of it is if you have a house worth more than $100,000, it will probably be, you'll get some relief. If it's worth less than $100,000, you won't. One thing I do want to point out that everybody ought to do, the property appraiser, the Madison property appraiser, has on the website a thing you can go on and click and see, will this actually give you any relief, right? And it'll figure out the dollar amount. It'll say, based upon the millage that's already been levied, you know, what's your relief going to be if this passes? And that's a really good thing to do, and just kind of see what's going to happen with that. Okay? Yes, ma'am.
If this is passed, will it affect other people's properties who homestead is not worth over the $100,000?
Okay, so if your homestead is worth $100,000, right? It's not going to affect you. What if your homestead is worth $125,000? You're going to get $25,000 reduction in taxable value.
Right.
Whatever your homestead is between that, that's the amount of reduction. So if you got a $110,000 home, you get $10,000 reduction in value.
Okay, but will the two homesteads that are in place will still remain in
Yes,
place?
ma'am. Yes, ma'am. This doesn't affect any of that. This is, if it passes, it adds one more homestead exemption.
One more exemption.
If it doesn't pass, it doesn't take away any. Yeah, it doesn't take away any you got. All right. Any questions on that before we move on?
What's this, you mentioned a skip between 25, what's that all about?
Well, the thought was this, and you know, and by the way, I promise y'all that I'm going to try to leave my personal opinions out of it. I don't guarantee that, but I promise you I'm going to try to do that. The idea though with that was that with the first 25,000, right? If you had, let's say, a single wide mobile home on a quarter-acre property, right? Mobile homes depreciate like personal property, not real property. And so after a few years, you could be below that 25 cap and you would basically be paying nothing. Now, is that a good thing or a bad thing? Y'all can decide that. But the point is that that person that has that would not be paying anything that the other people are paying for, you know, services and to support general government. The thought was, if you're going to increase that, that exemption, skip 25,000, put it on the next 25,000. That way, folks would have to pay something. Okay. Okay, that was the thought, and that's why you have those skips. See, is that the thought was that, yeah, you're giving relief, but even people at lower value homes will have to pay something.
Because plus there's another one for folks that are 65 and older, right?
Now those are different. Those are different. Yes, there is one for 65 and older. It's not a whole lot though. I mean, it's you know, $500 or something. I mean, but now those kind of questions about the actual dollar value, those are much better directed to the property appraiser, and they will go over that and they're very nice up there, and they're very accommodating, and they will go through those kind of questions a lot. Yes, sir?
How much of an impact does it have on the budget for the county?
Yeah, I don't know. I don't know the answer to that one. If you have a house that's over $125,000, the reduction in taxes, the total reduction in taxes is $260. Right? Now that's divided between county, school district, water management district, all of those. So you'd be looking, I would assume, at a reduction, let's say for the county, of $100+ per home that was in that tax bracket, that was in that assessment bracket. I don't know what kind of an impact that would have. But you know, as we were talking about though, the problem and what you want to weigh out with any of these exemptions is, you know, is this going to stop government from raising revenue, or is it going to shift the revenue they raise from this to something else? That's the question.
Tommy, I think one of the commissioners told me it'd be like 125 to 150,000 less in the general fund.
Yeah, yeah. And see, now we have our millage right now brings in, I think, $250,000, half mil maybe. So that's a pretty significant, you know, hit. Okay, let me move on. Number 2, this one is, now this one is kind of just the opposite. Okay, what this one is, this is when we got the other exemptions last time, right? What happened was, and if you look on page 6 of your handout, or that pamphlet, what happened was these exemptions came in years ago, and then if you look at the language that's got the lines through it, that's what they're talking about striking. That language says that, that there's going to be an automatic repeal of those subdivisions granting the exemption on January 1, 2019. If you vote for this amendment, you're voting to strike that provision that says there's an automatic repeal and keep those exemptions in. Does that make sense? What they did was they added exemptions. They said, okay, these exemptions are only going to be in effect for a certain number of years. If nobody does anything, they're going to fall off after a certain number of years. What this amendment is doing is it's saying they're not going to fall off anymore. If you vote for the amendment's going to keep those exemptions in place. Okay? And so that's where, if you're looking, and that is on page 5 and 6, you can see the 2 extra exemptions that are added on page 5, and then the stricken language there is the language that would make those exemptions go away.
So this is a yes or no, because I'm somewhat confused on this.
Okay.
I have it as no.
If you vote yes, you're going to keep the exemptions in place.
Okay,
If you vote no, you tell them to take the exemptions off.
okay, thank you.
All right. Now, all right, let's move on to number 3. Now, this is the one, and there's been a lot of, I've seen a lot of this on TV. It's dealing with gambling, and it's voter control of gambling. Now, if you look at, and this is on page 7, 8, and 9, and if you look at page 7, you start getting into the underlined text there. And actually, I should have said this earlier. The underlined provisions there, that's what they're talking about adding to the Constitution. Like where you saw before on page 6, and it's got the strike-throughs, that's what they're talking about deleting. So when you look at this, if this amendment passes, right, this underlined text on page 7, 8, and 9 will be added to the Constitution. Nothing gets stricken in this particular amendment, but if you vote for it, that's what gets added. Now, what they're saying here, if you look at A, the amendment ensures Florida voters shall have the exclusive right to decide whether to authorize casino gambling in the state of Florida. This amendment requires a vote by citizens' initiative pursuant to Article 11, Section 3. Citizens' initiative under Article 11, Section 3 is the way we do amendments to the Constitution. So right now, if you want to propose an amendment to the Florida Constitution, you have to get a certain number of signatures on a petition, and you have to get a certain number statewide and a certain number in each of the congressional districts in the state of Florida. So it's a pretty big task. And I don't remember the exact percentage. It's 5 or 10% or something, 20%. I don't remember what it is, but it's a big deal to get that. If you'll recall, the last one I think they may have done successfully was the medical marijuana that John Morgan pushed for that. And it took lots and lots of money for them to get all that together and get that citizens initiative together. So these aren't easy things to do. But what this is saying is to authorize casino-style gambling, you're going to have that process to authorize it. And so, of course, the result of that is it's going to be hard to get casino gambling in Florida. So, yes, sir.
Help me with some history here. Didn't we vote on this one time or two before?
What I think they are getting at is there was some issue in the Constitution about what is and is not prohibited by the Constitution. So, in other words, they're talking about things like slot machines, right? I think the legislature recently has allowed slot machines in various places. Some people think that shouldn't be allowed. The courts have said yes, they're going to allow it. This fixes that. It says that no casino gambling will not be allowed. Now, there are exceptions to this, though. And if you look at the next page well, B, it gives you a definition of casino gambling, and it includes lots and lots of stuff. If you get to all the kind of stuff that I would think of as casino gambling, roulette, craps, keno, slot machines, blackjack, all that kind of stuff. And then if you get to C, it's where we talk about the exceptions. Nothing herein shall be deemed to limit the right of the legislature to exercise its authority through general law to restrict, regulate, or tax any gaming or gambling activities. So if the people say they wanted casino gambling, that doesn't mean the legislature can't tax it, or the legislature can't say, well, you can't have it in certain areas, or that sort of thing. Now, in addition, nothing herein shall be construed to limit the ability of the state or Native American tribes to negotiate gaming compacts pursuant to the Federal Indian Gaming Regulatory Act. Again, as everybody knows, you have casinos on Indian reservations. That's all part of a, they negotiate agreements on how that's gonna work and where the tax money's gonna go and all that kind of stuff. And anyway, so I think that's the meat of it. Now, we already have, a lot of these types of games are at different places. So for instance, a lot of the places that used to have greyhounds, all that, well, now they have poker rooms and they have slot machines and that sort of stuff. And so the hope is, I think, of the proponents of this, is that if it passes, you're gonna knock out a lot of that. And you would not be able to have that. You would have to have a constitutional amendment to allow those things. Okay?
Question.
Sir?
Just the casino gambling, do you think that would bring revenue into a county? Maybe
Yeah.
that would help jobs, help bring jobs?
Well, the only thing I know is with casino gambling, there's no question it brings in revenue. Now, the other side of it is, though, what they say is, yeah, but you increase your DUIs, you increase your problems people have, social problems, all that kind of stuff. And I don't know that I necessarily have an opinion on that.
In Gaston County in line, if they ever be able to do it, Gaston County will be the first county that gets to it, because they've already been working on it for like 5 or 6 years.
The Gretna.
Yeah, correct.
Yeah. Yeah, yes, ma'am.
So I'm understanding exactly that this doesn't affect the laws that were in effect for the Indian reservation.
Correct. Correct. It doesn't affect that.
So they could come in even though another business could.
Well, it doesn't affect whether or not they can have casinos on Indian reservations. That's governed by that Federal Indian Gaming Compact. Now, I'm not an expert on that. I'm sure it allows casinos in some instances and doesn't allow them in others, but whatever that says is going to control on the Indian reservation. Okay? Questions? All right.
So no keeps everything like it is.
No keeps everything like it is.
What was that again?
He said no keeps everything like it is. That's right. And then, yeah, except for Amendment 2, I guess no does keep that true for everything except for 2. All right. Number 4, voter registration restoration amendment. Now, if you look, that's on page 10 and 11, and this is an issue that's been floating around Florida for a long time. In Florida, if you are convicted of a felony, you lose a lot of your civil rights. One of those rights is the right to vote. In order to get that vote back, let's say you serve your entire sentence, you get out of jail, you get back on the streets, you still have a fairly onerous process to get the right to vote back. You have to, governor and cabinet have to approve it. It's a big deal. I've never done that as an attorney, but people who have tell me it's a very big deal. Now, what they're talking about changing here, if you look at the bottom of page 10, it's saying the added language, which is that underlined language, says except as provided in subdivision B, which we'll get to. Any disqualification from voting arising from a felony conviction shall terminate and voting rights shall be restored upon completion of all terms of sentence, including parole and probation. So if I get convicted of a felony, I go to jail. Once I've served my time, once I've done my probation, done my parole, my voting rights get restored. It doesn't go to Tallahassee to ask them, will they please do it? It's just automatic. Okay? Now, but remember it said it's except as in subsection B. Subsection B, no person convicted of murder or a felony sexual offense shall be qualified to vote until restoration of civil rights. So if it's murder or a felony sexual offense, old rules. Governor and cabinet have to restore your rights. If it's something other than that, once you've served your time, once you've done your parole, once you've done your probation, your voting rights should be automatically restored. Oh, thank you, sir. Any questions on that?
Unless you want to name off all the felonies that might qualify.
There's a lot of them. There's a lot of them. All right.
Does this mean anything on the next page?
What are you talking about?
Page 11.
No, that, only the, and again, okay, on mine, which is printed out a little different than y'all's, that's page 10, page 11. Page 10 has the added language. What's on page 11 is already there.
It's already there.
Yeah, anything that's not underlined is already there. And so if you pass the amendment, they're gonna add that underline. part. And that's the part that says, once you finish your sentence, once you've done your parole, done your probation, you automatically get back your right to vote unless it is you were convicted of murder or a felony sexual offense. All right. Number 5. Now, this is one, all right, if you start with me on page 12, on A, and you see how they're divided, you got section 19, so all of this is underlined, it's all gonna be added. You got section 19, supermajority vote required to impose, authorize, or raise state taxes or fees. Now, for this to make sense, you gotta know how they do it now. How they do it now is, for the state, remember, is not funded by ad valorem taxes. Ad valorem taxes is the county, the city, special district, school board. The state is funded primarily from state sales taxes, gas taxes, corporate income taxes, not personal income taxes. We don't have a personal income tax in Florida, but you have a corporate income tax. That's what the state is funded through, right? So all your state programs, all that generally come from those revenue sources. So, and the way that is levied is, we have a legislature, you got 2 houses of the legislature. If a budget or a tax or a statute of any kind, but one levying a tax, is passed by a majority of the House and a majority of the Senate, signed by the governor, it's law, we levy the tax. But that only requires a simple majority, which is one more vote than the other side, right? So this is going to change that and say a supermajority vote is required. So let's go to A. Supermajority vote required to impose or authorize new state tax or fee. No new state tax or fee may be imposed or authorized by the legislature except through legislation approved by 2/3 of the membership of each house of the legislature and presented to the governor for approval pursuant to Article 3, Section 8. And then and then B is no state tax or fee may be raised by the legislature except through legislation approved by 2/3. So they have the same requirement for A and B, 2/3 of each house of the legislature. A says you can't create a brand new tax without 2/3 of each house. B says that you can't raise any existing tax without 2/3 of each house. Now, applicability, this section does not authorize the imposition of any state tax or fee otherwise prohibited by this Constitution, etc. So what they're trying to guard against there is they don't want somebody saying, oh, well, if we have 2/3, now we can have an income tax because this gives us the authority to raise any kind of tax we want by 2/3. That's what C is guarding against. That's why you have C in there. Okay, so, ma'am.
The majority of the House is 61 votes?
Gosh, I need to ask that. I don't really remember. I think it was, is it 100? I thought it was 140 in the House. Like 80 in the Senate and 140 in the House. I don't remember.
2/3 of that would be what, 61? 60?
It'd be a lot. I don't remember.
Okay.
So, but anyway, I mean, 2/3 is 66%. Now you need 51, so it's another, what, 15%? 120. Okay. All right. Any questions on that one? Okay. Okay. Now this is one of those that you got some things that are kind of mashed together here. It's on number 6. So, and you see the title, Rights of Crime Victims, and then it goes into judges. So, if you look on page 14 through 18, that's the ones dealing with the rights of victims. If you look on page 19, that's where we get into things dealing with judges. All right? Now, if we start on, and again, if you look on page 14, all of that language that's not underlined, that's what we have now in the Constitution. If you look on page 15, 16, 17, and 18, all of the underlined, that's what they're wanting to add. You vote yes, if over 60% of the people, voters in Florida vote yes for this constitutional amendment, we'll add all that underlined, just like with all the others. Now, what they're doing is they are putting more, I don't want to say more teeth, but they're putting more specifics in that. If you look at the language on page 14, and all criminal prosecutions of the accused, and anyway, that's talking about that. Down to state of Florida. All right, and then that's actually, okay, that one's actually talking more about the criminal, the accused. On B is where we're going to get into the rights of the victims. To preserve and protect the rights of crime victims, achieve justice, and ensure a meaningful role throughout the criminal and juvenile justice system, etc. They're going to have all these rights. So then we'll start at 1. The right to due process and be treated with fairness and respect for the victim's dignity. Okay? Right to be free from intimidation, harassment, and abuse. Right within. Now, and those two are probably more aspirational. I mean, there's probably not a, the right to be treated with dignity. I don't know how you really enforce that. That's, that's kind of subjective. But you start getting into like number 3, the right within judicial process to be reasonably protected from the accused and any person acting on behalf of the accused. However, nothing contained herein is intended to create a special relationship between the victim and law enforcement officer. The, now in number 4, 3 and 4, I think are kind of considered the same. The right to have the safety and welfare of the victim and victim's family considered when setting bail, including pretrial release conditions, etc. Right now, the when you set bail, and I'm not a criminal lawyer, but when you set bail, you look at a lot of things. The big thing for bail, though, right now, is this bail big enough to ensure that the accused will come back? Is it a high enough bail? What happens, practically with bail, if you set bail at a certain amount, they go to a bail bondsman, the bail bondsman puts up the bail. If they take off, the bail bondsman actually hires people that go get them and bring them back. And so that's kind of how that system works. The feeling of the people who proposed this was that not enough consideration was going into the rights of the victim. That, hey, even if this person we know they'll come back, how sure are you that they won't go hurt the victim? How sure are you that they won't do all that? That was, it's my understanding, that was a consideration, and they do take that in consideration when deciding whether or not to set bail. I don't think that is a consideration in the amount of bail at this point, on how high. I don't know if this would make it that way, but it says that that their safety and welfare have to be considered. So I think that's the issue. I'm always a little reluctant on things like this, though, when you're talking about criminal law, because so much of our criminal law is all based on the federal system now, right? I mean, no matter what we put in our Constitution dealing with search and seizure, we're all bound by the U.S. Supreme Court's decision on the federal search and seizure guidelines. No matter what we put in there on the Fifth Amendment, right against self-incrimination, we're all bound by the federal court's interpretation of that. So, I'm kind of a little reluctant to change that, because it just may create more confusion. We all have to follow the federal standards anyway. But there is some things I think it would be hard to argue in here. Okay, anyway, that's 3 and 4. 5, now, some of these I think are very, like number 5, the right to prevent the disclosure of information or records that could be used to locate or harass the victim's family, which could disclose confidential or privileged information. It's my understanding that that right already exists by statute, but, number 6, the victim shall have the following specific rights. A, the right to reasonable, accurate, and timely notice and be present at all public proceedings involving the criminal conduct, including but not limited to trial, plea, sentencing, all of that. Let's see. A victim shall also be provided reasonable, accurate, timely notice of release or escape of the defendant. I don't think anybody could argue with that one. The right to be heard in public proceedings involving pretrial or other release. C, the right to confer with prosecuting attorneys, right to provide information. It's just a laundry list of what I think most people would think are generally, pretty reasonable things for a victim to have access to. It's one of those amendments, though, I don't think they really know how that's going to affect, criminal prosecutions and all that. What you do want to be kind of careful of is, if you give the victim, if some of these are interpreted in such a way that would hinder the victim, the defendant defending themselves, then that may give a way for an appellate court to overturn the convictions. And so that's kind of where you're always trying to guard against. But all right. Any questions on that part?
Let's go to the judiciary.
All right. Now that starts on page 19. So you've got the first part under section 8, which, and what that's doing is it's changing the time at which, the age at which a judge has to retire from 70 to 75. But it's not just that simple, because the way it is now, it's the judge can't serve past 70 unless they have already completed more than half of their term. Judges have 6-year terms. So if they've completed over half their term, they can leave at 73, I guess. If they haven't completed half their term, they have to leave at 70, at age 70. What this does is it extends it to 75, but you don't get to finish out a term you've completed half of. You just have to stop at 75. My only comment is I think there's a definite need for an age limit. With judges, I think the difference between judges and other people with other jobs is there's not a real good way to fire a judge. And so when they get, and it is better for the people using the court systems, the litigants, that some very good and capable judges have to leave earlier than they otherwise would, than it is for one of them to get one that can't stay awake during trial. And I've had that. So anyway, I'll leave that way. But now, whether that should be 70 or 75. We should
vote yes for the rights and no for the judges.
No, you don't have that option. Yeah, you don't have that option.
That's my point.
So anyway, so that's the first part. Now the second part is a little more esoteric. Section 21, judicial interpretation of statutes and rules. In interpreting a state statute or rule, a state court or an officer hearing an administrative action pursuant to general law may not defer to an administrative agency's interpretation of such statute or rule, and must instead interpret such statute or rule de novo. De novo is Latin. It means in the first instance. You don't give any deference to anyone else. You are considering it de novo. Now, what is this about? Well, when you are, let's say you've got a case and you've asked DEP for a permit, like a wastewater permit, right? You ask them for a permit, they say they won't give it to you. Well, what do? Do you run off the circuit court? Well, no, you can't. What you have to do in that situation is you have to go to an administrative hearing officer. You go, or now they're called administrative law judges, at DOA. You file a petition, you go to DOA, that administrative law judge hears it, and then from there you can move into the appellate courts, but you don't, that's your trial, is there before the administrative law judge. Usually, when they are considering the issues, the courts are required to defer to agency interpretations that are both reasonable and are within the field of operation of the agency. So if you've got a statute, and the statute could be interpreted a couple of different ways, dealing with the environment, for instance, the courts are supposed to defer to the agency charged with enforcing that statute, right? Because that agency is, the thought is that it has special expertise and all in doing that. So the point of this amendment would, it would take away that deference, and it would say agencies, you don't get any deference. You just, everybody that shows up to court is equal, and we start from the beginning, as if no one had any deference. The people who lose in front of administrative agencies like this, the people who tend to win don't like this. That's about all I can tell you on that. I mean, it's one of those provisions that, it certainly sounds, I think, when you hear the way the law is now, it sounds right. I mean, because the way the law is now, it says,